invite at this juncture Rahmat Zakari to please give us to tell us the fact of the case, so that we'll be.
Good morning. Since inception, the Republic of Adanana, which is made up of diverse religions, faithful, is always witnessing different religious activities. On the 20th day of September 2010, who are known for their annual procession as one of the rites in propagation of their religion, took to the streets of Kanana. Men, women, and children, all dressed in black, with some faces covered with black and face coverings. As the procession went on, armed security personnel of the Republic of Adanana interjected. The leader of the security personnel approached the leader of the Kanana group and requested to see their police permit. In his response, the leader of the Kanana group told the security officer that they do not need to obtain any police permit before embarking on their procession, and that they were only exercising the right to lawful assembly and freedom of movement as guaranteed under the Constitution. At this point, the security officer insisted that his men search members of the Kanana group, especially those with black face coverings, on the ground that the country is facing serious security challenges, as a result of which he needs to ensure the members of the Kanana group are clean and are not carrying anything that will pose security threat to the nation. As the argument turned sour, the leader of the Kanana group insisted that their religion forbids men to search women. The leader of the Kanana group then instructed his members to proceed with their procession. But this did not go down well with the security personnel. While attempting to proceed with their procession, the security officer ordered his men to clamp down on the Kanana group, where men, women, and children were arrested and dumped in police cells at the force headquarters for 3 days. On the fourth day, the legal team of the Kanana group instituted a fundamental rights enforcement suit on behalf of the Kanana group and against the Republic of Adanana. At the trial court, 3 issues were raised and determined in favor of the Republic of Adanana. Dissatisfied with the decision of trial court, the legal team on behalf of the Kanana group have filed this appeal before the Court of Appeal on the following grounds: that the trial judge erred in law when he held that the right to freedom of religion of the Kanana group, as enshrined in Section 38 of the Constitution, was not violated by the security personnel of the Republic of Adanana. That the trial judge erred in law when he held that the right to freedom of assembly of the Kanana group, as enshrined in Section 40 of the Constitution, was not violated by the security personnel of the Republic of Adanana. That the trial judge erred in law when he held that the right to dignity of human person of the Kanana group, as enshrined in Section 34 of the Constitution, was not violated by the security personnel of the Republic of Adanana. Thank you.
Another round of applause for her, please. Please, a round of applause for him. I'm not seeing the light of the day, if not for contribution we have received from the young lawyers. So we sincerely appreciate, and we hope Allah subhanahu wa ta'ala reward you extra abundantly. Okay, behind every successful one there is always a woman. He's together, he's ably accompanied by his wife, Khadija Sadiq Maji. Distinguished ladies and gentlemen, may I recognize today, and also may I recognize Honorable Justice Ibrahim Umar. He is a magistrate presiding over Magistrate Court, Southern P. You are welcome, sir. Also in absentia, we have Sadiq Samaila Sadiq. He is the presiding judge. He is the judge presiding over Magistrate Court, EP. He will join us as soon as possible. I think at this juncture, I would like to step aside and allow him to proceed.
On the case of the Constitution. Yes, my Lord, case number C/NH/M/1
NANIGLAWS. Number 1, the President of the Republic of Adanana. 2, Attorney General of Adanana. 3, Department of State Security Service. 4, Inspector General of Police.
Parties and what?
Yes, my lord. May it please this honorable court.
Parties.
My lord, yeah, please this honorable court. Muhammad Abdullah Muhammad Abdullah S. I announce my appearance as the lead counsel for the appellant. For the appellant? Yes, ma'am. Yes.
May it please your lordships, A.K. Abubakar Esquire, I appear with my learned friends. A. Ahmad Esquire, U.T. Abdulmalik Esquire. Your humble appearance is at the instance of the respondent.
For the purpose of correcting the records of the court, our notice of appeal was dated 8th of December 2019.
Your lordships, your lordship, I have an application. Before you move this process before this honorable court, it's a very fundamental application, my lord. With your leave, I proceed.
It's already on its feet. Let us hear from him.
Ordinarily, my lord, I was surprised. Wait before I should adopt my notice of appeal. Then if I'm before that, then you raise the what you are supposed to raise. My lord.
Is your appeal right for hearing?
Yes, my lord.
Have you exchanged briefs?
Yes, my lord.
Let's hear him.
Thank you, my noble lords. Lord, we have an application, oral application for sale.
What is the nature of your application?
Bordering on the jurisdiction of this honorable court.
Is it right for hearing?
It's not time for hearing, my lord.
Have you filed?
Aside from the notice of preliminary objection before my noble lords, we have an oral application bordering on the jurisdiction of this honorable court.
Counsel, do you think this honorable court can hear your oral application? This is a court of appeal.
Very well, my lord, but my lord, as a matter of the fundamental nature of our application, because it has to do with the Constitution, my lord.
No matter how, no matter what the application is, do you think this honorable court can proceed to hear you orally?
Very well, my lord, that is the exception, my lord.
Refer us, please.
My lord, our application...
No, refer us to what gives this honorable court the power to hear you orally.
My lord, the issue of jurisdiction the issue of jurisdiction of this honorable court, as to the constitution of the court, it was never contemplated, not until when my noble lord stepped in. And as a matter of fact, my lord, as a matter of law, for a court of appeal to hear an appeal, it must be at least constituted by 3 justices, my lord. We refer my noble lord to section 247 of the Constitution, alongside section 9 of the Court of Appeal Act. With your leave, I read.
Counsel, the only thing this court asks you,
Yes, my lord.
whether we can proceed to hear your objection orally.
Very well, my lord.
Can we?
Very well.
What rule of this honorable court gives us that power?
My lord, I don't have it handy. As a matter of fact, when it borders on issue of jurisdiction, this honorable court can hear our application, my lord.
Applications before this honorable court are to come formally. I don't know whether you have the Court of Appeal rules with you.
Yes, my lord. We have it.
2016.
Very well, my lord.
Then can you go to 6 of the Court of Appeal rules?
I'm there, my noble lord.
So, how do you bring an application before the court as per that particular order?
Motion on notice, my lord.
So,
Motion on notice, my lord.
so
But my lord, it was never contemplated, not until when you stepped in. So we never knew that the number of justices will not be up to 3, because as a matter of procedure and constitutional matter, so we feel the court will be duly constituted. But as it is now, the court is not duly constituted, my lord.
Law.
Very well, my lord.
And there are set down provisions under the law. The procedural laws are there as substantive law. And we've just referred you to one of the provisions. If you must challenge the jurisdiction of it, it should be by way of money. Immediate file send and exchange send.
My lord, as I did say, this was never contemplated, not until when. That is the predicament.
yes, counsel.
Yes, my lord.
Indeed, ordinarily, when you have the court should actually adjourn. When we have such a predicament, the court cannot, of course, proceed with the hearing of the appeal because the court is not properly constituted, and this goes to the jurisdiction of the court. But for the purpose of this particular Moot appearance, the court shall proceed.
As the court
Yes, before you proceed with your brief of argument, I don't know, there is a process here. I don't know the position of the process.
the primary objection, sir.
Okay, let's hear him.
Yes.
Yes,
My lord, we have a process before you.
yes.
An application also challenging the jurisdiction of the court.
Have you served them on the
Very well, my lord. It has been served.
When did you serve them?
They were served yesterday, sir.
Yesterday?
Very well, my lord. Sincerely.
By the rules of this court, how many days do they have to...
3 clear days.
Let's hear from them whether they are waiving their right to reply C or what.
Yes, my lord, as craving to reply on point of law, but there is a begging distinction that I just noticed here. It appears to me that we are not in the same court, my lord. Ordinarily, on academic settings like this, we were appraised with the rules of engagement. Parties are bound by the fundamental facts given to them, and to which this is an academic setting. The setting to which this mooting stand is an academic setting, and we are bound by the facts given to us. And as such, my lord, the court is sitting at an appellate jurisdiction. It's a court of appeal, but in the Republic of Adanana. My lord,
Counsel, for them to proceed with their application.
Let them proceed.
As the court pleases.
Proceed.
Thank you, my lord. Before my lords is a notice of preliminary objection, brought pursuant to section 46 sub 1 of the 1999 Constitution as amended, and order 2, rule 1 of the Fundamental Right Enforcement Procedure Rules 2009, and under the inherent, my lords, am I on record?
You're on record.
And under the inherent jurisdiction of this honorable court, my lords, the prayers as are contained on the face of the motion paper. This motion is brought upon 5 grounds, my lord. With your leave, I proceed. 1, my lord, the action under fundamental right enforcement rules are taken up personally and individually by any person who alleges that his right has been or likely to have been infringed. 2, my lord, that cannot institute a common action jointly for enforcement of their fundamental rights. 3, my lord, proper party is not before this honorable court. 4, having regard to this appeal before this honorable court lacks jurisdiction to hear this appeal. 5, the violation of fundamental right enforcement procedure rules, quoted by 16 paragraphs of appearance, deposed to by one Jawad Muhammad, the secretary, the litigation secretary in the office. In compliance with the extant rules of this honorable court, we have also filed our written address. The fact is as contained in the affidavit. My lords, we formulated a loan issue for the kind determination of this honorable court. My lord, with your leave, we seek to adopt same as our oral submission. With your leave, we would like to elaborate on some salient issues, my lord. With your leave. Thank you. Which was improperly initiated and incurably defective, which robbed this honorable court of its jurisdiction. My lord, we submit that this suit was improperly initiated and incurably defective, my lord, as a result of which robbed this honorable court of its jurisdiction. My lords, on a careful perusal of Order 2, Rule 1 of the Fundamental Right Enforcement Procedure Rules, it is clear that the operative word there is any person, my lord. My lords, am I on record? The operative word is any person. Also, my lord, section 46 sub 1 of the 1999 Constitution is also clear, my lord, that any person who alleges that his right has been, is been, or likely to have been, my lord. Any person, that is the operative word, my lord. Any person. As such, we urge my noble lords to take judicial notice of the processes before them. It is our humble submission that this honorable court lacks jurisdiction to hear and determine this particular appeal. As such, we urge my noble lords to dismiss this appeal for the interest of justice. We so submit.
Any response?
Yes, my lord. My lord, on local standing, this court, on local standing on fundamental rights suit, this court held in the case of Okafor versus Lagos State and another. Okafor, or OKAFOR versus Lagos State Government and another. 2016. Yes. Law Pavilion Electronic Law Report. 41. Yes. 066.
Yes.
Judgment. CA. This one of the court, my lord.
Yes.
It was held, with your kind permission, my lord. It was held that the FREP provides a novel opportunity for initiation of fundamental rights suit. Being that FREP watered down the applicability of the mandatory requirement of local standing in instituting fundamental rights suit by providing that no suit shall be effective on the ground of the want of local standing. It is there in the solution. It is there in the preamble of the fundamental right enforcement procedure, my lord, particularly paragraph E of the preamble, my lord. And as a matter of fact, and on point of law, my lord, it's clear within the OAU from the evidence before this honorable court of the trial, in judgment of the trial court, we never initiated this or in this suit individually. We came as a juridical entity one, as the Kanana group, and it was held in this case, my lord, on who can sue and be sued in fundamental right suit. In the case of Okechukwu versus EFCC, Okechukwu spelled OKECHUKWU versus EFCC, 2015. All Federation Weekly Law Reports, part 76603. In this honorable court, my lord, court of appeal, and with your kind permission, yes, it was held that an artificial person can sue, can file an action for the enforcement of its fundamental rights, since companies, artificial person, can only act through human beings. If a limited liability company is not involved in the case where it is denied fair hearing, it has the right to sue for breach of its fundamental right. The emphasis here, my lord, an artificial person. My lord. We came, we found, we instituted our team as a Kanana group, not individually also. We urge this honorable court to dismiss the criminal objection raised by my brother.
Counsel, before you sit down, is Kanana Group a limited liability for?
It's a registered association, my lord.
Whose right is violated?
Yes.
Is it the right of Kanana Group,
yes,
as a company or as an entity, or the right of individuals that belong to Kanana Group?
The right of the individuals that belong to Kanana Group.
Sorry.
Preliminary objection of the respondent counsel and the response of the appellant. However, ruling on the same application is hereby reserved to the final judgment. Yes.
Yes, madam. Subject.
Yes.
Yes, we have a pending application before the son of the court.
Pending application.
On the 10th day.
Registrar, please take note of the time.
Dated on the 10th day of December 2019. But my lord, for the purpose of clarity and setting the record, the court proceeded. And we seek within the latitude for amendment of the court.
It is dated on the file what?
I served them via internet, via WhatsApp on the first day. But when we met yesterday, I served them with hard. So it was dated 10th. So it was dated 10th in mine, but well in yours. So we seek within the latitude of this one, but discretionary to amend it.
Fellowship. My lord, may I object? Thank you, my lord. My lord, I'm surprised. It's time to move what is not before this honorable court.
It is not before the court.
Very well, my lord. Reason being that, my lord, issue of fundamental rights is sui generis, and the maximum of the law is to be lura nobis corie, which means the court knows the law. My lord, on a careful perusal of the processes before you, my lord, it does not disclose that in the processes that has to border on enforcement of fundamental rights. I ought, my lord, to peruse, my lord.
Counsel, is there an appellant brief before the court? Were you served by an appellant brief?
My lord, I was served, but...
It's all right. Let them proceed. The court will do the needful.
As the court pleases.
Thank you, my lord. The subject to be considered is of this honorable court, my lord. We intend to adopt our said to the honorable court. Thank you very much. My lord, in the brief of argument and the notice of appeal, we appeal in the latitude of this honorable court, pursuant to section 241 of the Constitution, and I appeal on 3 grounds. And I read, my lord. Ground 1. The trial judge erred in law when he held that the right to freedom of religion of the people of Canada Group, as enshrined in section 38 of the 1999 Constitution, was not violated by the security personnel of the Republic of Ghana. And subject to the convenience of this honorable court, my lord, I shall be elaborating on this issue. And we've distilled issue from grounds 1. Most guided, my lord. Pages, in our pages 4. Be guided, my lord. Page 4. Particularly issue of 4.0. Issue A is thus: whether in the circumstances of this appeal, the learned trial judge was right when he held in his decision that the right to freedom of religion of the Canada Group, as enshrined in section 38 of the Constitution of Federal. Issue A is thus: whether in the circumstances of this appeal, the learned trial judge was right when he held in his decision that the right to freedom of religion of the Canada Group, as enshrined in section 38 of the Constitution of Federal Republic of Nigeria, 1999, as amended 2011, was violated by security personnel of the Republic of Ghana. And I see, my lord, it is pertinent to start with, for the purpose of consumption appreciation, to start by reproducing orally the provision of section 38 of the Constitution, particularly section 38 of 1 of the Constitution. I crave your indulgence and permission to read the provision. Allow. It's of 1 of the Constitution of Federal Republic of Nigeria, as amended 2011, provides thus that every person shall be entitled to freedom of thought, conscience, and religion, including freedom to change his religion or belief, and freedom either alone, my lord, either alone, my lord, or in community with others. The emphasis on my lord, or in communities with others, and in public or in private, to manifest and propagate his religion or belief. In worship, teaching, practice, and observance. And my lord, these noble people, these innocent people, crying for justice, were within this latitude, doing the same as contained in the provision of section 38 sub 1, to which they were intercepted. My lord, it is right, Lord, that the fundamental rights are rights that are not inherent, that are inherent, and in man by him being human. And that should not be taken away from any person without due course of law or affront of law, legal justification. I refer this honorable court to Olufemila Ransom and others, versus Attorney General of Federation, reported 1985. Citations are provided, particularly in page 5 of our brief of parliament, my lord, where Justice Cairo was, on commenting on the nature of fundamental rights, observe that the fundamental rights are rights which stand above the ordinary laws of the land, and which in fact is antecedent to the political society itself. It is a primary condition to a civilized existence. We are in the 21st century, my lord. And what has been done by our constitution is to have these rights enshrined in the constitution so that the right will be immutable, unchangeable, my lord. To the extent of the non-immutability of the constitution, the non-flexibility of the constitution, my lord. In the same vein, Parut, Vivo, Justice of the Court of Appeal, Justice of this Honorable Court, my lord, while discussing on the latitude of the provision of Section 38, in the case of a UK book versus NBC, the citations are provided, my lord, particularly in our pages 5, that he held us the right to freedom of religion is in fact inherent and inalienable, which includes neighboring right to propagate and manifest, which peradventure is antecedent to every civilized political setting, my lord. And we're in the 21st century. Furthermore, my lord, in Hassan versus Economic and Financial Crimes Commission, EFCC, the citations are provided, particularly in the first part of the petition, while commenting on the fundamental right enforcement and duty on court, which this honorable court is bound by it also, to maintain such, stated that, and I quote, fundamental rights are right to be held universal in the sense that all people have and should enjoy them, as they are freedoms essential to the concept of ordered liberty. This is why inherent in human nature and consequently inalienable. They are rights that belong without presumption or cause of privilege to all human beings. On the final note, my lord, the entitlement to freedom of religion is a right that is naturally invested in every person whose rights and obligations are called into question. It is not a right that the person to demand to be given. It is not a right that the person to demand to be given, but a right that must be accorded to him without him asking for it.
5 minutes.
Thank you. My lord, finally, a careful perusal of the record of proceeding has reflected in the decision of the trial court. The record,
Yes, proceed.
the respondent, the security personnel of the Republic, intercepted the people of the Canada group and prevented them from exercising their right to freedom of religion as enshrined in Section 28, particularly Sub 1 of the Constitution of the Republic of Nigeria. It was never within the record of the proceedings that there were lawful justification for curtailing these rights. And we urge this honorable court to resolve this issue in our favor and uphold this appeal, my lord. We're so cool. Thank you.
Yes.
With kind permission of this honorable court, I would like to argue on issue number 2, which is displayed from the second ground suit.
Yes.
Which is whether in the circumstances of this appeal, the land trial judge was right when it held that the right to freedom of assembly of Kananabu, as enshrined in Section 40 of the Constitution, was not violated by the security personnel of the Republic of Nigeria. Lordship, we answer this in the negative, due to the fact that Section 40 of the Constitution provides that every person shall be entitled to assembly freely and also associate with other persons, and in particular he may belong or form any political party, trade union, or other association for the purpose of protecting his own interests. Your Lordship, this Kanana group is a group that is lawful, which the Constitution has already granted individuals to form a group. And also, from the part of the case, I would like to refer this honorable court to page 3, paragraph 3, yes. Where the leader of the Kanana group said that no need of obtaining police permits before carrying out their religious procession. And your Lordship, obtaining this police permit restricts individuals from exercising their fundamental rights. In the case of ANPP versus IGP, Inspector General of Police, the Court of Appeal pronouncement whittled down the order, the Public Order Act. It whittled down the act because it restricts individuals from exercising their fundamental human rights. And I'd like this honorable court to accept the act of the parties as lawful.
You say you want this honorable court to what?
I think the permission of this honorable court to accept the act of Kananabu as a lawful act, even without obtaining the police permit, because the Court of Appeal has whittled down the act not to be applicable.
Which act?
The Public Order Act, Section 1 of the Public Order Act. Your Lordship, in the case of Inspector General of Police, the same case, but ANPP and 11
Order.
Adekeye JS held that the Constitution cannot be strictly interpreted like an act of the National Assembly, and it must be construed without ambiguity, as it is not supposed to be ambiguous. And all its provisions must be given its actual meaning and interpretation, even without the imperfection of the legal draftsman. Your Lordship, the provision of Section 40 of the Constitution is very clear and unambiguous, and we urge this honorable court to do so. Very clear and unambiguous, and we urge this honorable court to do so. And also in the case of IGP, the same case, Rabiu Dalami Muhammad, JCA, held that it is the cardinal principle of interpretation of statute that where the language of a statute is clear and unambiguous, the court must give to it as such. In that case, the word of the statute speaks the intention of the legislation. So, accordingly, Your Lordship, different judges have given their holding in this particular case, the case of ANPP and others versus IGP. Justice Abdul Abuki, JCA, also held that the provision of Section 40 of the section of the Constitution is clear, direct, and unambiguous,
It is formulated and designed to confer on every person the right to assemble freely and also associate with other persons. The right to assemble freely cannot be violated without violating the fundamental rights of citizens. Also, Your Lordship, that violation can only be done by the procedure permitted by law, and this procedure is with respect to Section 45 of the Constitution, which can be applied in the case of state of emergency. And Your Lordship, before applying these provisions, a state of emergency must be declared, in which case no state of emergency is declared in the circumstances of this case. Your Lordship, in the light of the above decision, we humbly submit that from the fact of the case and also the decision of the judges, the hearing of the judges as read to this honorable court, alongside the provision of Section 40 of this Constitution, I humbly submit that this honorable court should resolve this case in our favor and uphold this act. Thank you.
The appearance remain Y.S. Malcolm. I shall be addressing this honorable court on issue for determination number 3. With the kind permission of this court, I beg to read my issue for determination and proceed my oral argument proper.
Proceed.
Whether the conduct of bodily search done by the security personnel and clamping down on people of Kanana group and further dumping them in the force headquarters for 3 days amount to breach of Section 34 of the Constitution 1999 as amended. My Lord, I answer the issue in affirmative, i.e., their rights enshrined in the Constitution, particularly in Section 34, was violated. My Lord, the section reads those. Every individual, sorry my Lord, I beg the leave of the Honorable Court to read out the provision of the section. Every individual is entitled to respect for dignity of his person and accordingly. Paragraph 8. No person shall be subject to torture or inhuman or degrading treatment. My lords, from the words of this provision, it is clear that a person who the Constitution of such country has afforded to the person this right is entitled to such rights. And my lord, to my knowledge, I have never come across any lawful justification, unlike other sections of the Chapter 4, that justify the violation of such section or right. In this case, my lords, the Kanana group is their right to be recognized, to be treated as normal human beings, as other people in the society. For their rights, is their right to be respected in whatever way they do. My lords, this is in conflict. The act of the security personnel contradicts this assertion of or the provision of the Constitution. Their act that they search the female among the Kanana group, because the leader of the Kanana group told them that their religion forbids such search, that a man is not allowed in their religion to search female. In support of this, my lord, is a statutory authority. Section 44, sub 3 of CPC, my lord. Citation supply, I beg of the court to read out the wordings of the provisions. When the arrested person is a woman, my lord, the security personnel acted in contravention of this section. Furthermore, my lord, Section 6, sub 2 of CPA also imparitorial with the aforesaid section. I beg the leave to read out the provision of the section. Whenever it is necessary to cause a woman to be searched, the search shall be made by another woman.
Yes.
My Lord, it's clearly stated on the record of proceeding that the security personnel order for the search of those Kanana group women in contravention of this provision of the law. It is true that laws are not meant to be flouted. Laws are to be respected. We are to be guided by the principle of laws. And yet, the security personnel of the Adanana Republic were found in contravention of these laws. We are violating the dignity of those people. My Lord, I refer this Honorable Court to the case of Aroyi versus Ikunde of Federation Law Report 2015, batch 830, page 1233. Citation to be supplied, my Lord. I beg the Honorable Court to read out the holding of the case. My Lord, in that case, the justices define what it means, or what it means to derogate or trample upon someone's dignity of human person. And it defines those terms as inhuman treatment as treatment which devoid of feeling for the sovereign of others, and degrading treatment means revealing, holding one to public, lowering persons in estimation of the public, exposing him, and dishonor and contempt. My lords, from the holding of this court, and in trying to marry this holding of the court and what's transpired between the Kanana group and the Republic of Adanana, clearly shows that the security personnel have trampled upon their dignity of human person. Furthermore, my lords, I refer this Honorable Court to the case of Ayegi versus Ahmadu Bello University Zaria, part 851, page 177, on Federation Law Report. Also, my lord, while commenting on the inhuman and degrading treatment, the justices held an action which inflict intense pain to the body or mind, physical cruelty which endanger the life or health of a person, or an act done in such a manner as to bring a person to public ridicule. My lord, it's also clear here that the act of the security personnel of Adanana Republic towards the people of Kanana group, they also violated their rights of human person. They have ridiculed their public, they have disgraced in the public, they have ridiculed their personality, and lots more. My lords, in conclusion, in view of the above cited authorities, judicial and statutory, I so submit that the learned trial judge erred in law when it held that the dignity of human person of the Kanana group was not violated, and that it is my humble prayer before this honorable court that this appeal uphold and quash the earlier decision. That's also
and proceed.
The security officer insisted that his men search member of Kanana group, and the leader of Kanana group insisted that their religion forbid men to search women, and his instructed member to proceed with the procession. My lord, search officers were male, and those were to be searched, that the leader of the Kanana group protested.
All right, that's it. It's okay.
Thank you, my lord.
We intend to go on a short recess so that we will return shortly to enable us to be properly constituted.
My lords, having received the appellant processes, that is their notice of appeal, dated 10th day of December 2019, respectively, we, the respondents, have painstakingly navigated through the grounds of appeal, and we have studied the issue emanating therefrom. We have equally formulated 3 issues from the grounds of appeal. Issue 1 was formulated from ground 1, issue 2 from ground 2, issue 3 from ground 3, respectively. In line with the extant rules of this honorable court, my lord, we have filed our respondent brief of argument, dated 12th day of December, dated on file 12th day of December, and same has been duly served on the appellant. We respectfully urge this honorable court to adopt our processes and our oral submission in this appeal. With your leave, my lord, we shall be making an application for the court to afford a few minutes to adumbrate on some salient issue.
Yes, before you proceed,
yes, my
you
lord.
said you have a respondent brief of argument dated
12th day of December, my lord.
What we have before us is dated 10th. Are we having different process?
It's dated 10th. And the appellant brief is dated 12th December.
Your lordship, that's an oversight from our side.
So what do we do with it?
We shall be applying to correct it, my lord.
Yes.
Thank you, my lord.
Make the application.
My lord, we shall be seeking correction of the date, my lord.
From what to what?
My lord?
From what to what?
From 10th to 12th December. Thank you, my noble lords. My noble lords, can I proceed?
Yes.
We shall be applying pursuant to Order 608 of the Court of Appeal Rules that this honorable court should afford us few minutes to adumbrate on some salient issue.
Yes, as earlier stated, you have 15 minutes as the late counsel, but I can have 10 minutes each. And the registrar shall inform you when it is 5 minutes left. Proceed.
As the court pleases, we appreciate. I shall be responding on issue for determination number 1. With your leave, I read the issue and proceed with my argument proper.
Yes.
Yes, madam. Whether the trial judge was right when he held that the right to freedom of religion of the Kanana group as enshrined in Section 38 of the Constitution was not violated by the security personnel of the Republic of Adenana. My Lord, we answered the above question in the affirmative, and we urge this honorable court to so. Your Lordship, it is crystal clear from the record of appeal before this honorable court that the security officer only requested, my Lord, to search those with face covered to be sure if they are clean, my Lord. That was the only request, my Lord. We invite my Lordship to paragraph 2, the ending line 10 to line 15 of the record of appeal. With your leave, I read. May I?
What?
Record of appeal before this honorable court, my Lord. That is a fact. The mock fact before you, my Lord.
Yes, you may proceed.
Proceed.
Thank you, my noble Lord. Security officer insisted that his men search members of Kanana group, especially, my Lord, especially those with black face covering, on the grounds that, my Lord, on the grounds that the country is facing serious security challenges. Serious one, my Lord. That is their basis of searching them, my Lord, and nothing more. My Lords, there is no doubt that by virtue of Section 38 of the Constitution, they are entitled to freedom of thought, conscience, and religion. No doubt, my Lord. No doubt. But your Lordship, it is also apparent from the record of appeal that they do not in any way intend to infringe their fundamental right, my Lord. It's clear. My Lord, with this, we shall be referring this honorable court to Section 4 of the Police Act. With your leave, my noble lords, I read. My noble lords. My Lord, may I proceed? Thank you, my Lord. The police shall be employed for the prevention and detection of crime and the apprehension of offender. My Lord, these are the three operative words in this section: prevention, detection of crime, and apprehension of offender. My Lord, they were only trying to prevent the country from the security challenges we are facing, and nothing more. My Lords, by virtue of Section 45 sub 1, my Lords, paragraph A and B, with your leave, I read. My Lord, may I proceed?
Proceed.
Not on 45 sub 1, my Lord. Nothing in Section 37, 38, 39, 40, and 41 of this Constitution shall invalidate any law, my Lord, any, that is reasonably justifiable in a democratic society. My Lord, Police Act is what is a law that is reasonably justifiable in our democratic society, my Lord. Also, my Lord, paragraph A and B, in the interest of defense. My Lord, as we earlier on refer my noble lords to the record of appeal, where the security personnel said, in order to be sure that they are clean. That was their intention, my lords. And Constitution is also clear. For the interest of defense, public safety, and public order, my lord. Public safety, my lord. We are trying to protect our territory, my lord. Also, my lord, paragraph B, for the purpose of protecting the rights and freedom of others. My lord, it is apparent that you are entitled to these fundamental rights. But when your rights stop, that's the beginning of another person's rights. And, my lord, the maxim of the law used to be, solus populis suprema les est per. The welfare of the people is the highest law. Highest law, my lord. Highest.
5 minutes more.
Thank you, my noble lord. My lord, with this, we respectfully submit that this issue be resolved in our favor, and the judgment of the lower courts be upheld, and the appeal be dismissed for the interest of justice. We so submit.
You are arguing that Nigeria is a democratic society.
Very well, my lord.
Now, as a democratic society, would you say that Nigeria is a liberal state or rather a conservative state?
My lord?
As a democratic society,
Very well.
you just argued
Very
well that Nigeria is a democratic society,
Yes.
so to say. Now, as a democratic society, would you say that Nigeria is a liberal state or a conservative state?
My lord, I don't understand it.
What do you consider Nigeria to be? A liberal state or a conservative state?
Liberal state, my lord.
A liberal state.
Very well.
Very good. Now, under a liberal state, when the right of an individual conflicts with the right of the state, which one overrides the other?
The right of the state. Right of the state, my lord.
Order.
My lord, we have an authority in respect of that.
Okay, what is the authority?
Very well, my lord.
That under a liberal state, where the right of an individual conflicts with the right of the state, the right of the state overrides the latter.
My lord, in the case of, with your leave, my lord, of Bayero University's Ministry of Education, the then Oracle of Law, as he then was, just in his leading judgment, my lord, he said, and I quote, chaos, I repeat, chaos, I repeat, all over the country, no court should allow itself to be used as an instrument of subversion under the guise of enforcing fundamental rights. My lords, I'm still on track. A fundamental right, my lord, he said, a fundamental right is certainly a right which is above the ordinary laws of the land. That is not the ending, my lord. But, my lord, he said, but, the living oracle of law, my lord, I venture to say that no fundamental right, my lord, no fundamental right should stand above the country, state, or the people. My lord, with this, we submit that where the right of individual conflicts with the right of the state, the right of individual should be set aside. It's not my saying, but for the then living oracle of law, of the blessed memory.
Council,
Order.
based on your argument
Very well, my lord.
that the security of the state
Yes, my lord.
do prevail over individual rights,
Yes, my lord.
as rightly argued by you. Considering also the provision of section 45, derogated section, subsection 2,
Subsection 2.
yes, of the 1999 Constitution,
Okay, my lord.
that some conditions wherein the rights can be taken of an individual, which when there is a period of emergency. How can you reconcile that?
Very well, my lord. It is clear from the record of appeal that the country is facing a serious security challenge. So, my lord, it can be inferred from the record of appeal that the fact that the state of emergency was not declared, it was not clear that it was declared, but, my lord, it can be inferred from the record of appeal that the country is facing a serious challenges that need to be dealt with immediately, my lord. Very well, my lord.
We are bound by the record before us.
Very well.
Specifically an appellate court. It is when it is the facts put before it and evidences taken at the lower court that it will work with. Now before us, we've not seen anything. You are talking of inference. You want us to speculate?
My lord,
this is a court of law.
in respect of that, it's settled. Section 1, sub 1 of the Constitution, which provides that this Constitution is supreme and its provision shall have binding force on all authorities and persons. My lord, with this section, no section of the Constitution is superior to another. As such, my lord, Section 45, sub 1, paragraph A and B have made it clear that their rights can be infringed upon. As such, my lord, we submit based on that section, my lord.
At what point can we say that the security of the state has reasonably been threatened? What is the threshold for determining a security that has been threatened?
Yes.
And with the fact of the case, such as to warrant the state, preventing the people from exercising their rights. In this case, their right to the practice of religion.
I wouldn't like to.
At what point?
My lord, I wouldn't like to delve into that because my learned brother here will do justice to that part. Yes, ma'am.
Are you sure?
Very well, my lord. We will do justice to that part.
Proceed.
So, my lord, may I seek the leave of this honorable court? Thank you, my lord.
Yes,
Will the court be pleased? I am Abdulkareem Abdullah and I will be taking on issue 2 as formulated in our brief, which reads thus: whether the trial judge was right when he held that the right to freedom of assembly of Kanana group as enshrined in section 40 of the Constitution was not violated by the security personnel of Adanana group, Adanana Republic. Can I proceed, my lord?
Yes.
We are positive and we urge this honorable court to so hold. My lord, the security personnel has not in any way tempered on the right of the Kanana group as enshrined in the Constitution of the Federal Republic of Nigeria. The security personnel are only carrying out their duty as a security personnel. And in light of the record before this honorable court, the security personnel are only trying to act in a proactive manner, in the sense that they are trying to prevent a crime even before it happens, so that we will not come to be counting our losses. Instead of we counting losses, then we should prevent the crime before it happens. So that is why the security personnel need or obstruct the Kanana group from carrying out their procession and ask them of the permit that warrant their procession. My lord, Section 45 of the 1999 Constitution has provided that this right as guaranteed by the same Constitution that the Kanana group have the right to assemble and to carry out a religious procession can be derogated from when there is any law that has been passed by a National Assembly or any law in the state that is reasonably justifiable to derogate that particular right. And in line with this, my lords, the Public Order Act was passed, or was enacted, my lord. The Public Order Act has made provision that before you can carry out a public procession, you need to obtain the governor license. For you to carry out this procession, you need the governor license, and which is on record that the security personnel asked the Kanana group of this license, and they actually failed to produce any license, claiming that they don't need a license to carry out this procession. My Lord, it is no doubt that in carrying out procession, the appellant is exercising his right. But this particular right is not to be enjoyed in isolation of others. In carrying out this procession, the appellant will have to block roads, block other people from carrying out their normal daily activities. And in this sense, they are not only causing physical injury on the generality of the public, but also economic injury on the generality of the public. My Lord, the provision of public order Act has made it clear that you need this particular license to carry out procession. And the reason being that for the governor to give a clear-cut order or make a particular arrangement as to how you can carry out these procession without having a general effect on the public. So that is the reason why that it is very important for a person or a group while carrying out procession to seek the license from the governor before you can carry out this particular procession. And we refer this honorable court to the decision of this court in Louis Chukuma and two others against the Commissioner of Police. Citations so provided in our brief, page 6 of this particular brief. Although, my Lord, we want to be very clear to this particular court. The decision of this court in the case of IGP against AMPD is the effect that while carrying out procession, you don't require a police license to carry out procession. My Lord, distinguishing this particular fact in IGP against AMPP will be part before this honorable court. My Lord, we will see that there is a need for the Kanana group in this particular part to obtain the license before carrying out procession. And as such, 5 minutes now, this particular rule in IGP against AMPP cannot be applicable. My Lord, while making this particular rule or order in this particular case, the judge in the lords made a statement or made a ruling that the instance that necessitates the obtaining of order is when the state is an emergency. In the sense that this particular order from the IGP is based on the fact that that the Public Order Act to operate, there has to be an emergency that necessitates the application of the law. My Lord, it is with humility that I beg to disagree with the lords of the Court of Appeal, in the sense that while my lords are making their submissions in this particular case, they made reference to section 45 sub 2 of the Constitution of the Federal Republic of Nigeria, where the Constitution itself has made provisions that while in a state of emergency, measures can be taken to derogate from the provision of section 35 and 34, 33 and 35 of the Constitution. There was never mentioned in this particular section or subsection, section 40, my lords. Section 40 was not mentioned here. That there has to be an emergency before you can look or say that there is a need for me to obtain a public police license or a license to carry out procession. Because the position of the law is that where there's an express mentioning of a word in the statutes, it works automatically to exclude other words that are not mentioned. Since section 33 and 35 has been mentioned here, section 40 was not mentioned here, my lord. It means that this particular section, in relation to emergency, is only working on section 33 and 35 of the Constitution. So, my lord, we submit that our own submission that the security personnel acting in line with the provision of public order, which is a law sanctioned by section 45 of the 1999 Constitution, has not violated the right of the Canada group And my lord, the rule also in ITP against AMPP is not applicable to this particular case, given the peculiar part of this particular case, my lord. And also, my lord, the provision of section 45 has made it clear that this right can be derogated upon where this particular right is not, because this particular right is not to be enjoined in isolation of other people's rights. And I refer this honorable court to the case of Ambumota Obobu Mbenefu against Unwatilebe, Henry Moloku, and 2 other citations were provided, where the Justice of the Supreme Court, Peter Odi, made the following observation that the implication of what I'm trying to put across, sorry, my local laws, I bear this on contrary, that the implication of what I'm trying to put across is that the right of the appellant cannot be granted in isolation of the right of other persons within its community. Therefore, we so submit that the trial court was right to have held that the right of assembly of the appellant has not been violated. My lord, we so submit that the right has not been violated and urge this honorable court to uphold the decision of the trial court. May I see this leave of the honorable court to call on my lead counsel to move an application for my next counsel to proceed.
The counsel that just submitted, you make an attempt to distinguish between the case of AMPP versus IGP with the current case at hand.
Yes,
but you didn't drive home your point. How can you distinguish that case with the case at hand?
My lord, in the judge against AMPP, the part of that particular case is quite different from this particular case.
How?
The part in
what
the case,
happened in IGP?
It was after the general election, protest in their own grievances that they are not satisfied with the result of the election.
So it was more or less like a rally or a procession.
Objection, my lord. Objection, my lord. What he's saying is misleading. That isn't the correct.
Can you sit down? Yes.
My lord.
What he's saying on what? With respect
on the fact of the case of IGP versus AMPP and 11 others, my lord.
What happened in that case?
My lord, before they carried out the procession, they were in the meeting.
Yes.
People who were in the meeting.
All what the court is interested to know, was it a procession or not?
It was a procession in form of...
Sorry. So how can you distinguish it now? In this particular case, it was a procession by members of a particular group. In that case, it was also a procession. Where is the distinguishing line?
They are trying to prove that they are not satisfied with the election. But it's become something of a common knowledge that when people are not satisfied with this, with any particular... My lord.
It means both were processions.
Both were processions.
Sorry.
But the difference...
It's alright.
Thank you, my lord.
Sorry. Insinuate that the police were trying to prevent a crime.
Yes, my lord.
What crime were they trying to prevent?
My lord, or a crime that, because this procession has been held by this Kanana group. My lord, from the records of proceeding here, it is on record that they were all dressed in black. My lord, some of them are even covering their faces. My lord, why would I cover my face if I have nothing to hide? My lord.
What if it's your face that you want to hide?
My lord, I'm so handsome that I do not want to cover my face.
What crime are they trying to prevent?
My lord, let me bring for my brief. My lord, they took to the street in their numbers with these particular numbers and this dressing they are engaging. My lord, this is a prima facie terror that the public are put into fear. Because by the time you see people...
So now fear is now a crime. To put the public in fear is a crime.
My lord,
because you are carrying out your procession. You are exercising your rights.
My lord,
is it a crime?
The police are trying to prevent a crime. In the sense that they are trying to prevent a crime, they are trying to prevent anything that will disturb the public order. My lord, holding procession and you are all dressed in black, you are causing terror in the public. People will start running around. My lord, this is prima facie an act of terror. In the sense that, my lord, I'm quoting from a it's not necessary to have the intention to commit this particular crime, so long their presence in such number raises terror to harm to raise terror and alarm within the neighborhood. My lord, this is an authority. I know, my lords, we are only persuasive in relation to relying upon a foreign authority. But it's so persuasive enough to say that while a person in our locality, we have a lot of clothes that you can wear to have your religious possession. Although they say that is their own religion. You don't argue and say that they can't practice their religion.
What we are trying to say, what we are trying to say, will they likely happen?
My lord, from the Public Order Act, Section 3 says that if you are carrying out a procession without the license, you are already having an offense. Section 3 of the Public Order Act. Objection, my lord. It's misleading, my lord.
What are you objecting? What is it misleading?
My lord.
The court is taking the record and the court will read it in the course of it. Counsel,
my lord,
what is the position of the Public Order Act? Taking into consideration the decision of the court in IGP versus AM, position of the Public Order Act.
The position of the Public Order Act.
Freedom of assembly,
yes, my lord,
of individuals.
Yes, my lord.
What is the position of that?
That is the reason why I try to distinguish. The position is that in the position is that the learned judges in the justices of the Court of Appeal in the particular case are saying that you don't require the police permit. Police permit, my lord, Section 1 of the Public Order Act says that you require the governor license to carry out a procession. So the fact that the judge says that.
When the court now said yes, you don't need it, what is the position? Do you go by the act or you go by the decision of the court? Or do you have any contrary position of the law?
My lord,
aside what the court held in the case of IGP versus AMPP?
my lord,
not section of the law. Do you have any judicial authority?
Contrary to my lord, I have a judicial authority. The case of Louis Chukwuma, as I cited.
When was it decided?
It was decided 2005, my lord.
When was IGP versus AMPP?
2006 also. Yes, 2007, my lord.
So, which is the law?
My lord,
which is the law?
In particular response to your question, my lord, not in relation to the argument I'm canvassing, my lord.
Between the two decisions, which one is the position of the law? Thank you, counsel. Thank you.
Caution. The lead counsel to the appellate. This is a court of law, my lord. This is a court of law. And our profession requires what? Decorum, my lord. My lord, he has been interjected since. But because we want to comply with the rules, that is why we decided to make it formally before my noble laws. As such, my lord, we shall be making application that my lord should caution him.
You are protected.
With your leave, my lord, we shall be applying that the third counsel be given a few minutes, my lords. Thank you, my lord.
Respectfully, with us, UT Abdulkareem. As earlier proceeded by my lead counsel, I shall respond to issue 3. With the leave of this court, I read that the trial judge erred in law when he held that the right to dignity of human person of the Canada Group, as enshrined in Section 34 of the Constitution, was not violated by the security personnel of the Republic of Adanana. My lords, we answer this issue in the affirmative, and we urge you to so hold. My lords, the practice of the law is settled that the police shall have the power to detect crimes, apprehend offenders, preserve law and order. In respect of this, I refer my noble laws to Section 4 of the Police Act. With the leave of this Section 4. The Police.
Police Act, Section 4.
Yes.
Thank
you, my lords. It is clear from the above provision in subline with the record of appeal, particularly lines 10 to 15, which states, which you by the emphasis hours. At this point, the security officer insisted that his men search members of the Kanana group, especially those with black face coverings, on the ground that the country is facing serious security challenges, as a result of which he needs to be sure that the members of the Kanana group are clean and are not carrying anything that will pose security threats to the nation. My lords, a cautious look at these lines of the record of appeal, it is clear that the security personnel discharge their constitutional duties. That is, they only requested to search, my lords, to search the Kanana group, not to arrest them, my lords. That was what they requested, and the Kanana group proved recalcitrant, my lords. My lords, a community reading again to section 4 and 24 sub 1A of the Police Act. It also empowers the police to prosecute any suspected person, my lords, any suspected person that have committed an offense or been about to or want to commit an offense. My lords, it is clear from the record of appeal that the Kanana group were protesting in black and also covering their face. My lords, protest, a lawful, even if it is a lawful protest, covering face with black is a threat to the national security. It's a threat to the national security, my lords. As such, my lords, it is a conceivable and it's a fact that the powers of the police is very wide, and it must be exercised and performed without any discretion, my lord, without any discretion left to any responsible operative for salutary ends. My lords, we humbly refer this honorable court to the case of Ichiruka Okanu versus CPO, Imo State. Citation is before me, lords, with the leave of this court. My lords, am I on record?
Yes, you are.
That a citizen, emphasis ours, that a citizen who is arrested by the police in the legitimate exercise of their duties, and on ground of reasonable suspicion of having committed or want to commit an offense, cannot sue the police in court for breach of fundamental rights. My lords, the latter trial judge was right that the provision of section 34 of the Constitution, as averred by the appellants, was not violated without any brutal attack. It was never violated, simply because the security personnel only requested to search the members of the Kanana group in order to be sure that they are clean. And my lords, they were carrying a protest which was not even licensed nor permitted. And again, my lords, they were covering their face with black dresses. My lords, a protest wearing black and covering face, my lords, is a threat to national security. It's a threat. And my lords, it is clear from the record of appeal that this country is facing a serious security challenge. As such, my lords, the security personnel constitutionally discharge their duties by requesting the members of the Kanana group that they want to search them, and the leader failed recalcitrant by commanding or ordering its members to continue with their lawful protest, which later became so. My lords, In response to the appellant's brief, particularly page 9, my lords, they cited section 44, my lords, sub 3 of the Criminal Procedure Code. My lords, that section is inapplicable to this instant matter. It's inapplicable, my lords, so far as I'm concerned. My lords, the law is clear. It's clear beyond parameter. What the operative word used in this section, my lords, with your leave I read, emphasis hours, when the arrested person is a woman, when the arrested person is a woman. My lords, the operative word, when the arrested person, that is, the arrest has been taking place. And my lords, from the record of appeal, in fact, it was never mentioned that the members of the Kanana group were arrested. The only request to search them, my lords. It is clear, my lords. So I don't know why the appellants were.
And what's then if they said that an arrest has been effected?
My lords, arrest immediately a lawful security personnel confined the movement of a suspect or person suspected by tapping him at the back. My lords.
That is an arrest.
That is when an arrest is said to be effected. Immediately he confined his movement. Arrested has been effected in that circumstance. But my lords, they did not, in this circumstance, my lords, in respect of the record of appeal, they only requested.
When a custody, let's say dumped or kept in a single police cell, is that an arrest or what is it? What can we call it?
My lords, in respect of this and from the record of appeals, yes, they were done clearly. My lords, it's a lawful justification as to that. It's a lawful justification.
In the police cell,
that,
the police cell.
Yes, reason being that.
Does that constitute an arrest or not?
It constitutes an arrest. Then, my lords, what transpired that they were dumped in the security cell, my lords, they proved recalcitrant to the police, to the security personnel. They proved recalcitrant.
You see, to my mind, I think the argument is they were unlawfully arrested. And now you are saying there was not even an arrest. It's an afterthought.
So what are we even arguing? If there is no arrest.
If there is no arrest, we are not arguing that dumping them in the police cell was not an arrest. It is an arrest. The Milots, they also committed an offense. That's why they were arrested. In respect of that. That is the offense they committed. They proved recalcitrant to the security personnel.
If we get you right now, you are saying that there was an arrest.
When the police requested them for search.
Did they arrest them or not?
They arrested them, Milots. Milots, I equally refer you to the case of Dokubo Sadiq. Milots,
what is your submission?
It is a humble submission that the trial court was right that Section 34 of the Constitution has not been violated, and we humbly pray that this appeal should be dismissed and the decision of the trial court should be affirmed and restored forthwith.
Hierarchy of authorities, citing of authorities in courts, when the decision of the court conflicts with that of the statutory authority, which one prevails?
Because the judicial authority prevails.
About today's program. Well, as I've already said, that this program is unprecedented. I'm very impressed with the performance of the presiding judges and the counsel for the parties. For a lawyer to succeed, the it requires the knowledge of law. It has to be honest, and it also requires a good research skills and command of language. All these are found during the presentation, and I'm very happy with what I've seen. The future of our noble profession is very, very bright. From the stand of view, my stand of view from what I've seen, transpired. I'm very, very impressed, and I commend them for organizing it.
Thank you, sir.
Thank you so much.
Good afternoon, sir.
Good afternoon.
You, as a registrar, what can you say about the gathering today?
Quite impressive. They are young lawyers in the making. As you can rightly hear from there, it's a moot court proceeding. Just an imitation of what is usually happening in the court of law. From what the young lawyers have exhibited in the courts of these moot court trials, they have performed very well, worth commending, but I never expected to see the way they argue. It's not what I perceive to see here. But to be very frank with you, I'm impressed with what they've done so far. Alhamdulillah.
Thank you, sir.
You're welcome.
Good afternoon, sir.
Good afternoon.
Can you tell us the purpose of gathering of today?
Well, we are here today to celebrate the week and the convention, 2019 convention for the National Association of Niger State Law Students, NANIGLAWS. Part of the law week is a moot court trial that have been designed for the aspiring lawyers in the profession to come and showcase their talent of advocacy. That is why we're here today.
Being of the issue that actually those lawyers practice inside the judgment, how do you see their movements and the way this, their actions of judgment?
Well, from the nature of the appeal, the grounds of the appeal and issues argued before the court.
Yeah.
Even if I'm a presiding judge, I must say it's a difficult one because both parties marshaled out their points very, very intelligent in an intelligent manner, and they both have grounds for their arguments. So as it is the tradition with the profession, I can never preempt the decision of the judges. We will await their decision.
Thank you, sir.
Thank you very much.
Done really well. All of us started from there, and today we're members of the bar. I assure you what we're doing in the court is not different from what you just did today. I would just like to pinpoint some important issues for you to take notes in case of next time. I realize that the briefs of argument were all dated the 12th day of December 2019. Ordinarily, appellant brief ought to come before the respondent brief, because the respondent brief is in response of the appellant brief. It cannot be dated the same day. Please take this correction. And also, I expected the respondent to not to proceed actually with the preliminary objection, because no matter how prepared you think you are to respond orally, what is contained in the preliminary objection by the respondent may be carrying more weight. And by virtue of Order 10 of the Court of Appeal rules, you are entitled to have 3 days to be served with the PO 3 days. I was expecting the respondent counsel, that is the appellant you, to actually raise that point, and we will now abandon the PO because we cannot take another day to allow them to come and move it, so that we'll just go into the substantive appeal, or you allow it to go. It's actually a good one anyway. And lastly, Honorable Justice Ross Vivo is the Justice of the Supreme Court now. One of the counsel actually referred the court to a decision he made while he was still at the Court of Appeal. When you do that, you actually say as he then was, but the counsel did not say that, so just take note of that. I wish us the very best in all our endeavors.
Especially the direct participants and those who have been working round the clock, to ensure the success of this program. I'd like to thank or congratulate especially the president of the association, for coming up with wonderful innovation, and then for giving you all a platform, where you will all showcase your potentials. I see that the sky is the limit, and I wish you the very best. Now, coming down to the issues or the facts as the table before us, I would like to start by saying that all the council put in a wonderful performance, and then I am very much proud of you all, and I see you doing very well in the nearest future. Now, I would like to adopt all that my learned brother Abdulkareem has said before I bring out some of my observations. And then I would like to start by saying that the council, especially the respondent, because I didn't get to hear the argument of the appellant. Now, there's something I used to do when I was just where you are now. I used to do mock trials, and what have you. Once you stand up to argue a matter or an issue, as it is the case, you try as much as possible to define the key words of your issue, of what you are defining. Sometimes you take these things for granted, but then it actually helps you, in building a logical argument, which is actually very, very important in convincing the judge. It's not about oration most of the times when you come to court. It's actually about convincing the judge or judges, as the case may be. So most of the times you find out that counsel emphasize more on trying to impress the judge or the justices, and then forgetting to actually build a logical argument. So I see this, in the line of the argument of the respondent. Like I said, I didn't hear the argument of the appellant. Try as much as possible before you start your argument to define the key issue of the argument. If you are arguing, say, on the, let's say, right to freedom of assembly, try to define to the court what freedom of assembly is. Try to define to the court what right to dignity is. You can paraphrase your issue. You don't have to, these are some of the things that you can, there are things you can paraphrase, there are things you can even overlook. You understand? But never take the opportunity of convincing the judge, for granted. Try as much as possible to define a key word that you're defining. For example, the third counsel to the respondent, you're supposed to be arguing on the right to dignity. But I think you spent much of your time on then arguing on the assembly, freedom of association and all that. You should have anchored the argument strictly on the right to dignity. How were they arrested? How were they clamped upon? How were they all taken to a police cell? Is it as a result of, because you are arguing on behalf of the state, so you can say that the state does not have the resources, or the state does not have the capacity, to start distinguishing all of them. You can argue as a matter of expediency, that it was actually expedient that they were arrested in the manner that they have been. That it is as a matter of necessity. You know, by the time you're able to draw that line, you would have been able to convince the judge, you know, that there was not sufficient time, you know, to have accorded dignity any respect than was necessary. I don't know if you follow me. You know, that was necessary. So you ought to have drawn that line. You know, the point of exigency, you know, the point of absolute necessity. You know, so, and then, yes, the lead counsel to the respondent. Sometimes the judge may throw at you a question that you probably were not prepared for. Okay. Yes, so you can actually evade, you know, diplomatically. You can say, my lord, if I answer that question, I might lose my chances of reaching a logical conclusion. Or probably I would have preempted the argument of my learned brother. You see, you have actually evaded the question, but you have done it diplomatically, such that the judge, or you know, as the case may be, maybe a magistrate or what have you, will not, you know, take offense or will not see that you actually don't have a good response. But you know, by putting it diplomatically, you would have been able to have told the judge that you know the answer, but then for the sake of reaching a logical argument, or for the sake of not preempting your learned brother, you do want to answer the question. In all, you have done very well, marvelously, and I'm very proud of you. Owing to time constraints, I will allow the presiding justice to make his final comment, and then I will call out the results.
Well, I will start by actually congratulating the council for their wonderful performances. I also appreciate the presence of our important dignitaries and the organizers of this program. The organization was all wonderful. It's Friday, the day is far gone, and we don't want to take much of your time, almost time for prayers. Looking at the council, honestly, I was really, really baffled, because I was having mixed feelings whether lawyers already called to the bar we are talking to me, or are they law students from the academia? As actually pointed out by chairman of the Young Lawyers Forum, we have two lawyers that perform wonderfully as such in reality, in practice today. Being that in the academia you are all exposed to theories, more of theories, you're not even getting to the law school where you'll be exposed to the practical aspect of the law, and you are having this kind of performances. I think the sky is the beginning of your success. Keep the best, keep everything, and you all emerge victorious. I wish you all the best in your career. Composite ruling. Remember, in the course of your presentation, the preliminary objection was taken. Ordinarily, we are supposed to give a ruling on that before taking the main appeal. We adjourn it to the final day of the judgment so that we give our composite ruling on that. My learned brother will give you a course.
So the judgments and rulings are reserved.
Distinguished sanction of discontinued support to Niger State law students and administration of justice. This award will be presented by the national president and shall be received by the director. Okay, it shall be received by this year litigation High Court of Niger State on behalf of the Chief Judge of Niger State.
Here's the camera. First year too. Yeah.
Suleiman Yusuf Malcolm, please get ready. Gifts. And Amina. Thank you very much, sir.
Look here.